According to the complaint, Banks and his co-conspirators allegedly worked together to, quote, track, stalk, and attempt to murder a target at a Los Angeles gas station.
The streets might be dead, but the courtroom is very much alive. Lil Durk beating this murder for hire case was up in the air until he hired his top ops lawyer, Drew Findling. Drew Findling has filed 2 different motions to dismiss this case in the LA County's federal district. On the first motion to dismiss, Drew is going after the original superseding indictment. On the second indictment, Drew Findling is targeting the prosecutor's credibility and even his credentials to prosecute the Lil Durk's case in the first place. Now, we all know why Lil Durk is facing a murder for hire charge. The feds are alleging that Lil Durk paid OTF members and hired a private jet for the same OTF members to go to California and track and kill Quando Rondo. But they missed and ended up killing Quando Rondo's cousin. But if you've been living under a rock,
rapper Lil Durk has been arrested and charged with a murder for hire plot. The Chicago native, whose real name is Durk Banks, was arrested in Florida by the U.S. Marshals Service. The 32-year-old's arrest comes as 5 other people in Chicago were arrested in connection with the investigation. According to the complaint, Banks and his co-conspirators allegedly worked together to, quote, track, stalk, and attempt to murder a target at a Los Angeles gas station, firing at least 18 rounds into the person's vehicle, striking and killing a passenger in the car. Banks made his first court appearance this afternoon in Miami. Banks' lawyer asked for privacy after leaving court, telling ABC, quote, "We will not be commenting at this time."
The feds indicted Lil Durk on song lyrics and a text message between him and one OTF member. That's it. The text message to OTF Kwani said, "Make sure you don't use anything OTF or related to me when booking the flight," which necessarily doesn't prove anything. And the song lyrics? Lil Durk had the producer of those same songs come to court and testify that the songs were actually produced before the attempt on Quando Rondo's life. So that's why Drew Findling filed his first motion to dismiss and free Lil Durk. But the federal prosecutor objected and told the judge to wait because they have a mountain of evidence. But we haven't seen the prosecutor present any more evidence yet. Now, if you remember, the feds arrested OTF Jam, OTF Kwani, and 3 other members. Not too long after that, Lil Durk booked a flight to Italy, Florida, and Dubai. And the feds thought he was trying to flee the country to somewhere with no extradition. So I think the feds rushed to file a complaint against Lil Durk before he could flee the country. And the feds thought Lil Durk would just sit in custody while the feds built their case against him. Now, after I reread this, I realized this is vague at best. It says, the bounty language. The indictment introductory allegations contain the following language with respect to alleged bounty. After the murder of DB, Davon Bennett, King Von, defendant Banks, Lil Durk, made it clear in coded language that he would pay a bounty and a monetary reward and or make payment to anyone who took part in the killing of TB for his role in DB's murder. Now, the only part that got me messed up is, if he made something clear, but it was coded language, then doesn't that mean it wasn't clear because it was coded? And where is the coded message? Because the coded messages is just that one text message saying, don't use my credit cards because they can get traced back to me. That's not really that coded to me. Now, this next piece, I believe the feds are trying to introduce this as evidence, but it's just their narration of the story. The indictment's introductory allegations state that Mr. Banks, Lil Durk, directed the actions of his co-conspirators as follows. After learning of TB's location, Quando Rondo, at the direction of defendant Banks, defendants Wilson, Jones, Lindsay, and Houston, and co-conspirator 2 traveled from Chicago, Illinois to Los Angeles, California for the purpose of murdering TB. As alleged in counts 1 through 3 on August 19, 2022, at the direction of defendant Banks, defendant Grants, Wilson, Jones, Lindsay, and Houston, and co-conspirator 2 used 2 vehicles to track, stalk, and attempt to kill TB by gunfire. With respect to count 1, conspiracy to commit murder for hire, the indictment alleges, at the direction of defendant Banks, defendant Grant would procure cars, ski masks, and firearms that would be used by co-conspirators to find, track, and kill TB. Now, the whole time Lil Durk has been fighting this case, I've been waiting for more evidence to come out. More snitches, more witnesses, some fingerprints, something. But the federal prosecutor hasn't brought a shred of any new evidence. At first, they were saying Lil Durk was offering a substantial amount of money for the bounty on Quando Rondo. Then it was, Lil Durk is offering an OTF record deal, but nothing is concrete, and a dangerous strategy the feds are using. Because if you don't say anything concrete, you can leave it open for interpretation heading into trial. And that's where Lil Durk's lawyer, Drew Findling, is taking an issue. You have to give Durk's lawyers something to fight. If the prosecutor alleges that Durk offered $500,000, and then it turns out he only offered an OTF contract, the prosecutor's credibility goes out the window. So Drew Findling's first motion to dismiss would start by saying, this indictment is impermissibly vague. It leaves the defense to guess as to the government's theory of guilt, and it leaves the government free to change that theory as its cooperators' stories morph over time to meet the demands of a conviction. Because the indictment omits the factual particulars necessary to give Mr. Banks notice of the charges against him and to permit him to repair his defense at trial. It fails to satisfy Federal R, Criminal P, 7C, 1 and the 5th and 6th Amendments. See, the prosecutors are keeping it extremely vague so they don't get tripped up in trial and they can pivot to any workable theory that'll fit their narrative at the time of trial. It's a dirty game they playing, but dismissal is warranted as an alternative to dismissal. The motion seeks a bill of particulars under Federal R Criminal P7F, along with the 5th and 6th Amendment. Counts 1 and 2 allege that Mr. Banks conspired to and participated in murder for hire, in other words, a murder as consideration for the receipt of and consideration for the promise and agreement to pay anything of pecuniary value of what the government calls a bounty. See 18 U.S.C. 1958 A.B.1, defining anything of pecuniary value to include anything of value in the form of money, a negotiable instrument, a commercial interest, or anything else the primary significance of which is economic advantage. And here we are back with the vagueness. Anything else the primary significance or economic advantage? Now that's a crazy net to cast over. Because Lil Durk is a millionaire and he's been taking care of his people for years now. He pays rent, he pays for funerals, he pays for cars, you name it. So the feds being this vague means anything can fall under that umbrella. And that's what Drew Findling is taking issue with. Now the second motion to dismiss brings up another angle that even I didn't see coming. The at direction angle. I said it was some vague text messages, but I was waiting for them to bring evidence as to how Durk directed them. And Drew Findling addresses that as well. A similar deficiency plagues at the direction of language that affects every count in the indictment. All the indictment alleges that the co-conspirators carried out various acts at the direction of Mr. Banks, flying to Los Angeles, tracking, stalking, and attempting to kill TB by gunfire, and procuring the firearms and equipment used to do so. It fails to give any specifics. When and to whom did Mr. Banks give these alleged directions? To ensure the basic fairness of this trial, the defense is entitled to know. Given the vagueness of this indictment bounty and the direction of the allegations, if the indictment is permitted to stand, a bill of particulars is warranted. Mr. Banks requested a bill of particulars that reflects the theory upon which the grand jury rested its charging decision and that gives Mr. Banks fair notice of the allegations against him. Specifically, we request the following information. 1. The language that Mr. Banks allegedly used to convey his offer of pecuniary bounty in exchange for the murder of TB. 2. The nature of the item of the pecuniary value, the monetary reward or music opportunity that Mr. Banks is alleged to have offered and or delivered in exchange for the murder. 3. The date and time, audience, and circumstances of the alleged bounty offer. 4. The language used, date, time, audience, and circumstances related to the direction of allegations in the indictment. This request is made under Federal Rule of Criminal Procedure 7 and 5th and 6th Amendment. Now, the first motion to dismiss, I'm sure the prosecutor can use some tricky legalese to get past that. They've been blowing a lot of smoke and hot air at Durk's court dates. But the second motion to dismiss, this one goes at the prosecutor's jugular. It demands Lil Durk's basic rights as an incarcerated individual. You're supposed to tell anybody after they're arrested the evidence you have against them. It's called discovery. And Drew Findling is attacking their core allegations by attacking the lack of evidence in their allegations. There's a reason why Drew Findling is one of hip-hop's favorite lawyers, because he can find a way to get almost anybody off, which he's done in the past, and he might have just done today. Because it turns out Durk's superseding indictment is unconstitutional? This is the district attorney who brought charges against Lil Durk, acting U.S. Attorney Bilal Esali. Now pay attention to the words, acting U.S. Attorney. I believe that means he was interim U.S. Attorney and wasn't even allowed to bring charges against Durk at the time of him sitting in office. The designation of Bilal E. Asali as U.S. Attorney for the Central District of California violates the Appointment Clause of the U.S. Constitution. Asali lacks authority to conduct the prosecution as he was not lawfully appointed as a federal officer. Continuing to fund Asali, who was not lawfully appointed, and his office violates the Appropriations Clause. Asali does not meet the criteria to be an appropriate acting official under the Federal Vacancies Reform Act. Asali serves as U.S. Attorney exceeded the 120-day limit under 28 U.S.C. 546(c)(2), making his actions after July 30 of 2025 unlawful. The use of funds by Asali, an improperly designated private citizen, to prosecute the case of violate the use of funds by Asali, an improperly designated private citizen, to prosecute the case of violate the Appropriations Clause. The indictment should be dismissed due to Asali's lack of lawful authority. Asali and all attorneys under his supervision or paid with misappropriated funds should be disqualified from the prosecution. Now, this is a bombshell of a dismissal. Lil Durk's lawyer is basically saying that the prosecutor is a substitute teacher who should have been replaced after 4 months. But because he wasn't replaced, all his actions after the 4-month mark should be negated. And anyone under him in the prosecutor's office should be off the case as well. And I'm not gonna lie, that's one hell of a loophole. Lack of Senate confirmation. The Appointments Clause requires the president nominate and, with the advice and consent of the Senate, appointed all the officers of the United States, including U.S. attorneys. Asali, a private citizen and political ally, was appointed by the Attorney General without Senate confirmation, which is not permitted for wielding prosecutorial power, but can be permitted if he got into office under the Federal Vacancies Reform Act. Unfortunately, Asali doesn't meet the criteria under the Federal Vacancies Reform Act to serve as an acting U.S. attorney. He was neither an already in place first assistant, a Senate-confirmed officer in another role, nor an already in place senior official in the U.S. Attorney's office, making his actions as an acting officer invalid. Now, that was a lot of information to unpack right there. But short story shorter, I think Lil Durk is coming home a lot sooner than anybody gave him credit for. But that's to the credit of Drew Findling. He's gotten Gucci Mane off, NBA Youngboy, and a slew of other rappers in the hip-hop industry. But let's be honest, do we really think Durk is behind these allegations? I don't know. I only know what you guys know. I'm not OTF Inc. T. But let me know in the comments, do you think Lil Durk is on his way home? Or do you think the judge is going to overrule these dismissal charges like he did the previous ones? And if you made it this far, click the left side of your screen to see why the Young Jeezy snitching allegations have resurfaced. And also, don't forget to leave a like, comment, subscribe, share to be aware, put me that album because I need to be there, man. Because I know there's 10 other streamers out there doing it like me, but fuck that little 10. I'm maxed out.